It wasn't supposed to go like this. Not for a royal. Not in a courtroom packed with reporters. Not in front of a judge who, until that moment, had maintained every ounce of British restraint. But then, the warning came. And when a judge pauses open court to issue a stern, direct, and unmistakable caution to Prince Harry, it means something's already gone terribly off script. Let's ask the uncomfortable question: what does it really take for a British judge to warn a prince? In public, on the record, and what the hell was going on behind the scenes when it happened? Because make no mistake, that wasn't theater. It was a signal. And if you read between the lines, if you listen to the careful pauses, the narrowing of questions, the legal team's sudden silence, you begin to see it clearly. Something broke down. And it didn't break with shouting, or table pounding, or scandalous revelations. It broke in silence, in confusion, in a slow, steady unraveling of control. Minute by minute, word by word, on the witness stand. And the only question left now is whether Prince Harry even realizes it, or if the courtroom he tried to command has now completely turned against him. So what actually happened? And why now? Let's pull back for a second. Because if you're just hearing the headlines, Harry's lawyers walk, judge intervenes, courtroom drama erupts, you might think this is just another royal tabloid whirlwind. But this isn't a story about celebrity. This is a story about credibility. This is a courtroom, not a press room. And in court, there's no audience to win, only a judge to convince. So when Prince Harry walked into London's High Court earlier this week, suing Associated Newspapers for what he claims was illegal surveillance, phone hacking, and targeted intrusion, he didn't just walk in with years of public grievance. He walked in with everything to prove. And as the early hours of testimony began, it became clear. He wasn't just trying to recount what happened. He was trying to win something deeper: vindication, validation, voice. But the problem with personal truth in a courtroom, it has to withstand cross-examination. Now here's where it starts getting strange. From the start, legal observers noticed something was off. Harry's answers weren't tight. His recollections wandered. His team didn't interrupt. Some of his statements blurred timelines. Others leaped into emotional commentary. More than once, he answered questions that hadn't been asked, defending not just his case, but his entire public image. Was he trying to defend the legal argument, or was he trying to prove something else? Was this about data theft, or decades of media trauma? Was this a plaintiff, or a prince pleading to be heard? Those tensions were real. You could feel them in the courtroom, but judges don't deal in emotion, they deal in evidence. And as Prince Harry's testimony drifted further from the narrow legal claims into broader reflections, the discomfort in the courtroom grew louder. Without anyone saying a word, that's when the first break appeared. And the judge, he leaned in. Let's pause. Ask yourself something. What does it take for a judge, an impartial authority, sworn to maintain neutrality, to issue a stern warning in the middle of royal testimony? We're not talking about subtle guidance. We're talking about an official caution on conduct, on tone, on relevance. Not behind chambers, in open court, in front of press, with a prince sitting at the center. Ask any legal analyst. That is not normal. Not unless the judge sees the case sliding off the rails. Not unless the witness is taking risks the court can't allow. Not unless the courtroom itself, once measured in calm, is beginning to spiral. And yet, that's exactly what happened. Why? Let's rewind. When Harry took the stand on Monday, it was already a high-pressure appearance. The lawsuit against Associated Newspapers had been brewing for months. He claims the publisher, through methods that may have included private investigators, phone tapping, and even bank record access, systematically invaded his privacy for years. He says it wasn't just illegal, it was coordinated, a campaign, a pattern. And he's not just suing for damages. He's trying to set a precedent, to say, this is where the line is. This is how far you went. And this time, you don't walk away. But here's the catch. Even if the invasion happened, the courtroom isn't just here to believe you. It's here to test you. The burden of proof is high. The standards are sharp. And when emotion replaces clarity, even in a case involving deep personal violation, the court can only tolerate so much drift. And this is where things began to fall apart. Witnesses are supposed to respond to questions, not tell stories. They're expected to support claims with specifics, not memories. But Harry, clearly impassioned and deeply affected, didn't always draw that line. He referred to headlines he felt were invasive, without confirming who authored them. He described phone calls he believed had been intercepted without documentation. He painted a picture of trauma, understandably, but the legal foundation beneath it, sometimes missing, sometimes thin, sometimes just not there at all. And as his testimony unfolded, the prosecution's job got easier. Because the less focused Harry's answers became, the more the defense just had to let him keep talking. In a courtroom, the longer a witness wanders, the more they risk contradicting themselves, and the more the judge watches. Now, imagine you're Harry's legal team. You've prepped for weeks. You've built a careful structure. You've told your client what to say, what not to say, where the traps are. And suddenly, mid-testimony, your client starts drifting, speaking from memory, injecting commentary, taking control of the room. What do? Do you interrupt? Risk undermining your own witness in front of the judge? Or do you wait? Hope he recalibrates and stay silent? That silence was deafening. Legal analysts noticed it. Reporters noted it in live coverage. The defense, by contrast, remained utterly composed, not aggressive, not emotional, just waiting, letting him go deeper. And that's when the judge spoke. The courtroom tensed, not because the judge raised his voice, he didn't, but because of what he chose to say and what it implied. A stern reminder to stay within the bounds of the case, to answer questions directly, to respect the legal process, not the media drama surrounding it. It was controlled, but unmistakable. The message beneath it, you're losing the room. Bring it back. And in that moment, everything shifted. The tone, the temperature, the tempo. The courtroom wasn't just listening anymore. It was tracking. The judge had marked the line. And now, every step Harry took would be watched twice as closely. So where does that leave us? We have a prince who feels deeply wronged by the media, by the system, maybe even by the very institution that raised him. We have a courtroom now caught between raw emotional testimony and strict legal boundaries. And we have a judge whose patience may already be running thin, but this story isn't finished. Not even close. Because what happened after the warning, what followed behind the scenes, inside the legal team, between cross-examinations, would shift this case again, and no one saw it coming. So let's go there. Let's step back into that courtroom, not the one in the headlines, not the one splashed across social media, but the one behind closed doors. Quiet, pressurized, measured. What was really happening in those early minutes? Before the warning, before the silence, before Harry's own legal team started falling out of rhythm, because those first few minutes tell us everything, and no one was paying enough attention. Here's a question. What does a courtroom feel like before it goes sideways? Now what does it sound like? Now what does it look like? What does it feel like? There's a tension to it, a kind of waiting, like everyone is holding their breath, but no one is sure why. That's how observers described the atmosphere that morning. Not explosive, not hostile, just off. Harry had entered just past 9:45 a.m. Dark suit, eyes forward, no hand-holding, no entourage, just the slight stiffness of someone walking into a space that doesn't fully belong to them. This wasn't a red carpet. This wasn't a palace hallway. This was the High Court of Justice in London, and prince or not, once you're through that door, titles don't carry weight. Only your testimony does. And that's where things began to drift. From the outset, the judge, Mr. Justice Warby, kept a calm but unmistakably direct tone. Formal, procedural. He wasn't there for theater. He was there for structure. But Harry? He wasn't following the structure. At least not entirely. Within the first 15 minutes of questioning, his responses began to wander. Not dramatically, just enough to signal something wasn't sinking. Instead of giving tight, factual answers, Harry would step out into context. Explain motives. Describe patterns. Reflect on emotional tolls. To the public, that might sound like depth. To a courtroom, it sounds like drift. And here's the problem. Courtrooms don't operate on vibes. They operate on evidence chains. You say your phone was hacked. When? By whom? What publication published the result? If you can't link those clearly, fact by fact, source by source, you don't just weaken your case. You invite scrutiny. And that's exactly what started happening. Not loudly. Not immediately, but bit by bit. Through glances, through murmurs, through the subtle shuffle of papers behind counsel tables. You could feel it. The prosecution was stepping back, letting Harry speak, letting the rope extend, Let's talk body language for a second. Because sometimes, the most revealing thing isn't what someone says, it's what the people around them don't do. Observers in the gallery noted something strange. Harry's own legal team, who had spent weeks preparing this testimony, suddenly became very still. No interruptions, no clarifications, no visible attempts to redirect. It was as if they were waiting too. But waiting for what? Now pause there. Imagine you're one of Harry's barristers. You've coached your client on staying within legal bounds. You know the dangers of oversharing, of speculating, of performing. And yet, in front of the judge, with cameras nowhere in sight, your client starts veering off script. Do you step in? Or do you let it ride, hoping he'll recalibrate? That's the calculus happening in real time. Because if you correct him in court, you risk undermining him. If you don't, you risk losing the judge. And in that balance, hesitation crept in. Meanwhile, the defense, stone-faced, measured, saying almost nothing. And that silence, that was strategic. Because when a witness talks too much, when they move from facts into feelings, it becomes easier to pick those statements apart later. It's not about what you say, it's about what you open yourself up to. And with each extended anecdote, each personal reflection, Harry was widening the target. Let's get even more specific. At one point, early in testimony, Harry described a headline that, to him, confirmed media intrusion. He insisted the only way that information could have been published was through illegal means. Except, the publication date he cited didn't match. It was off, not dramatically, but just enough. The courtroom noticed, not a bombshell mistake, but a crack, a shift. Because if the judge sees inconsistency early on, it doesn't just raise questions about that detail. It raises questions about everything that comes next. So now we're watching a slow unravel, not explosive, but surgical. The witness is passionate. The legal team is quiet. The defense is patient. And the judge, watching, not reacting, not yet, but the tension is building. And everyone in that room knows it. Here's where things cross a line. Roughly halfway through the morning session, Harry is asked a direct question about the timeline of an alleged information leak. Instead of answering with dates or documentation, he responds with a reflection, a broad statement about media culture, about trauma, about years of feeling hunted. Valid? Maybe. Legally relevant? Not quite. And that's when the judge speaks. Not loudly, not angrily, but firmly, reminding the witness to answer the question directly. To remain within the scope of the claim. To respect the court's time. It's a warning, and it lands hard. Because this isn't just anyone being corrected in court. This is Prince Harry. And now the courtroom energy changes completely. No more ambiguity. No more tiptoeing. The judge has made it clear. This testimony is veering dangerously close to narrative, not evidence. And from this moment on, every sentence matters more. Every pause is heavier. Every legal team decision. What to say, what not to say, carries consequence. Because what's unfolding now isn't just a legal argument. It's a battle for control of the courtroom. And Harry? He may have just lost the upper hand. But what came next would change everything. And no one saw it coming. It started slowly. After the judge's warning, you'd expect a kind of recalibration, right? A pulling back. A mental reset. Some indication that the message had landed. But that's not what happened. Because Prince Harry didn't retreat. He leaned in, not recklessly, not defiantly, but with something harder to define, something that looked, to those watching closely, a little like determination and a little like disbelief, as if he couldn't quite believe he was being told to stop. Not here, not now, not when he was finally being heard. And that's when his testimony began to shift, from legal to personal, from structured answers to lived experience. And from there, the line between truth and strategy started to blur. Here's the thing. In most courtrooms, witnesses are advised, over and over again, to keep things objective, specific, anchored in documents, dates, facts. But Harry, he did the opposite. And it didn't happen all at once. It started with a sigh, a long pause, a visible calculation before responding to a seemingly routine question about how he discovered certain articles had published his private details. And instead of saying, "I found out through X publication on Y date," he said something else. He talked about how it felt. He talked about betrayal, about the shock of seeing something he'd only told a close friend appear in a tabloid sidebar. He didn't name the friend, didn't name the journalist, just described the moment, the feeling of it, the chill. And suddenly, the courtroom wasn't in a timeline anymore. It was in Harry's head. Let me ask you something. What's more powerful in a courtroom? Clarity or emotion? The answer depends on what you're trying to win. If you're after sympathy, emotion works. If you're after a verdict, clarity wins every time. And that's the contradiction Harry walked straight into. Because as his testimony deepened, it also began to widen, stretching beyond the case at hand, into memories of Diana, the paranoia of flashbulbs, the way Meghan was treated, the fear for his children. Now don't mistake me. None of it was irrelevant to him. You could see that. This wasn't performance. It was personal. But the courtroom isn't built to hold that kind of grief. Not without structure. And the further he drifted, the more vulnerable he became, not just emotionally, but legally. Because now, his claims were being supported less by proof and more by pain. Let's sit with that for a second. We don't talk enough about what it costs to relive trauma in a room full of strangers. The kind of composure it takes to speak clearly about deeply invasive moments. Photos published, voicemails leaked, private outings turned into front-page spreads. And for Harry, those weren't just events. They were proof of the machine, the one he's been fighting his entire life. So when he started to testify, part of him, maybe most of him, wasn't just trying to win a case. He was trying to make the court feel what it had been like to live under siege, to be born into a role you didn't choose, only to be stalked for it, to be framed, exposed, dissected, and then dismissed. Day after day, you could argue, that was the real case he was trying to bring, not about data breaches, but about dignity. And if that was his goal, he was succeeding. But if the goal was to satisfy legal burden of proof, that's where things started to crack. At one point, midway through cross-examination, Harry is pressed again on specific articles. The defense asks, "Do you recall how this story about your former girlfriend's travel plans was obtained?" A simple question. He hesitates, then gives a powerful, honest, and, crucially, unverifiable answer. "I just knew. No one else could have known. It had to have come from surveillance." Now stop. Listen to that carefully. Not "here's who I think leaked it." Not "we have a report confirming it." Just, "it had to have come from surveillance." It's a belief, an instinct, maybe even true. But in court, it's thin ice. And the defense knew it. They didn't challenge the feeling. They didn't push back on the emotional detail. They just noted, he hadn't answered the question. And suddenly, the courtroom got quieter again. Now here's where the contradiction deepens. Harry was at his most compelling when he was at his least strategic. When he dropped the rehearsed language. When he slipped into memory. When his voice broke just a little. That's when people listened. Even the judge. But that same vulnerability, the kind that resonates on a human level, is exactly what creates legal risk. Because it's imprecise. It's nonlinear. It's emotional. It opens doors. And the defense, they walk through them slowly, methodically, without ever having to raise their voice. Just nudging him, letting him keep talking, letting him stray from the rails. At one point, he said this, "I've lived with the echoes of what happened to my mother for my entire life. And now, I see it happening again, to my wife, to me. And it's not just headlines. It's harm." The courtroom didn't move, but you could feel it. That's not a legal point. That's a cry. And for a moment, the courtroom wasn't thinking about article timestamps or metadata trails. It was thinking about Diana. And that's the trap. Because the moment emotion takes over, the facts blur. And the longer Harry remained in that emotional register, the more the courtroom, slowly, began to pull away from him. Not because they didn't believe he'd been hurt, but because hurt isn't enough to win. Let me ask you directly, if you were on the bench, watching this unfold, watching a witness slowly drift into unresolved trauma, what would you do? Let them speak? Or intervene again? The judge chose the middle path. He let Harry continue, but his body language shifted, leaning back, hands steepled, no longer writing notes, just watching. And legal analysts later said, that's often the most dangerous moment for a witness. When the judge stops asking clarifying questions and simply observes, that's when judgments are forming. And Harry? He kept talking. He was on a mission to make them all see it, to make it real. But in doing so, he may have stepped even further away from the only thing that could save his case. Precision. And then, somewhere between another story of a leaked voicemail and a reference to paparazzi waiting outside school gates. His lead attorney leaned in, whispered something. Harry paused, and when he turned back toward the judge, his face had changed. Whatever was coming, whatever was whispered in that moment, would mark the beginning of a second unraveling, not of testimony, but of trust. And what followed caught even the defense off guard. You could almost miss it, how fast it happened. Just a quiet exchange, a lean in, no shouting, no courtroom theatrics, just a lawyer whispering to a prince. A nod, a breath, a pause, but it meant something had shifted, and everyone in that courtroom, especially the judge, felt it, because in legal proceedings, silence isn't neutral, it's loaded, and when it breaks, especially with a correction, it usually means something is about to detonate. Let's be honest, courtrooms aren't built for drama, they're built for order. A deliberate pace, a clear protocol, every move logged and measured, so when a judge raises his voice, or even just interrupts, it lands like a hammer. And when a judge issues a formal warning to a witness mid-testimony, it's not a slip-up, it's a signal, a flashing red light that something very real has crossed the line. And in this case, that line was credibility. Let's go back to the moment itself. Harry had just finished a particularly emotional reflection on the press, the toll on his wife, and the echoes of his mother's life, playing out again in front of the cameras. The gallery was quiet. You could hear shuffling, a cough in the back. But the judge, he didn't move at first. Then slowly, deliberately, he sat up straighter, not leaning forward, not yet, but engaging, focused. He asked Harry to clarify a specific point about an alleged leak and how the story made its way into a specific Daily Mail column. Harry answered, but the answer was long, too long. He didn't get to the article. He returned to grief, to the concept of harassment, to fear, and that's when the judge stopped him, flat, mid-sentence, not to criticize, but to remind. Your Royal Highness, the judge began, steady and restrained. Please confine your response to the particulars of the question asked. It was formal, polite. But beneath the surface, a second message pulsed. This is not a memoir. This is sworn legal testimony. And that moment, those 12 words, marked a boundary that could no longer be crossed, not even by a prince. Let's pause here, because this wasn't just a procedural warning. This was a judicial reprimand delivered in real time, in front of the press, in a courtroom already vibrating with tension, and it meant several things at once. First, the judge was losing patience, not with the content, not with the pain, but with the format. Harry wasn't answering questions. He was reframing them, and in court, that undermines the entire process. Second, the warning was protective of the court's time, protective of the burden of proof, and, ironically, protective of Harry himself, because the longer he drifted into emotional territory, the more exposed he became to rebuttal. And finally, it was predictive. If things didn't change, if testimony didn't tighten, consequences would follow, and not just reputational ones, legal ones. Let's be clear about something. Judges don't enjoy issuing public warnings. They're not trying to humiliate anyone. They'd prefer everything run smoothly, especially in high-profile cases involving public figures. So when a judge chooses to intervene, it's never impulsive. It's a considered decision, and it always comes with weight. So what was Harry's reaction? He blinked, just once, then nodded, softly, no words. Just a flicker of acknowledgement. But his voice, when he resumed, had changed. Still composed, but lower, more cautious, measured. The room noticed, because now, he was aware of the line, and how close he had come to crossing it completely. Here's where things get interesting, because the warning didn't just affect Harry, it sent ripples through both legal teams. His own barristers shifted posture, some leaning forward, hands clasped, eyes narrowed. You could almost feel them recalibrating strategy in real time. How do you continue? Do you press forward, hope he regains footing, or do you pull back? The defense, meanwhile, did nothing, which was its own kind of move. No smiles, no notes passed, just stillness. They were watching now, not Harry, the judge, because once a judge makes a move like that, you can almost hear the new playbook being written in the room. Stay calm, stay sharp, and wait for the next misstep, because now, the pressure isn't on them, it's on Harry. Let's talk about why this moment matters so much. Because from a legal standpoint, a judge's warning can have implications that ripple through the entire trial. It can shift how testimony is interpreted. It can reset how jurists, or, in this case, the judge himself, evaluate witness credibility. It can even influence sentencing later on, if the case escalates. But in the court of public opinion, it's a catastrophe. Because suddenly, this isn't a story about Harry fighting the tabloids. It's a story about Harry being corrected by the very system he hoped would finally vindicate him. The narrative flips, and the defense knows it. Now, you might be wondering, was this a turning point? The answer isn't simple, because Harry did regain some composure. He answered more directly afterward. He stuck to specific articles, leaned on his legal notes, avoided wide emotional detours. But something was different. He was now on edge, no longer in command, no longer storytelling. Now he was reacting, and that's dangerous, because when a witness is reactive, they make mistakes, tiny ones, slips in phrasing, overstatements, and in a case as tightly scrutinized as this one, that's all it takes. The rest of the session played out quietly. No more warnings, no more raised voices, but the air in the room had changed. Something was fractured, not completely, not irreparably, but enough, and that fracture would deepen later, not during cross, not during redirect, but in the private hours that followed, behind the doors of the legal chambers, when murmurs began, when reporters whispered, and when someone on the legal team made a decision no one expected. Because that warning, it didn't just draw a line in the sand, it signaled that the tide was already shifting. And before the court reconvened the next day, something quietly and suddenly broke apart, but not in the courtroom, behind it. They didn't show it at first. The lawyers, I mean, even after the judge's warning, even after the courtroom mood had clearly shifted. Harry's legal team kept their expressions composed, hands folded, eyes down, whispered notes, occasional nods. But there was a difference, so subtle it was easy to miss. They weren't steering anymore. They were reacting. And in high-stakes litigation like this, when the legal team falls quiet, it's not because they've run out of strategy. It's because they're recalculating. And behind those sealed chamber doors, as day one wrapped and court adjourned, the recalculations turned into something else entirely. Here's what we now know. Late that evening, hours after the courtroom emptied, several members of Harry's legal delegation met privately. Not unusual. Every team regroups. But this meeting? It ran late. Too late. And the next morning, only some of them returned. Others? Gone. And no one gave a reason. Not the court. Not the palace. Not even the remaining lawyers. But sources close to the courtroom began using one phrase, over and over again: strategic disagreement. And once you hear that phrase in a live trial, you know things are fracturing. Let's unpack this. Legal teams, especially those representing high-profile clients, operate like tight units. Every move is mapped, every answer pre-cleared, every witness moment rehearsed dozens of times. Because in court, inconsistency is a liability. So when lawyers start leaving mid-trial, that's not strategy, that's collapse. Now, the official line, if there even was one, was vague. Scheduling conflict, not involved in this specific portion, that sort of thing. But legal analysts watching closely weren't buying it, because one of the departing lawyers had been seated directly behind Harry the entire first day, not off to the side, not removed, central, active, taking notes, whispering guidance between sessions, and then, nothing. No statement, no name, no replacement announced, just gone. So the natural question becomes, why would a lawyer walk away from a royal client in the middle of a case this public? Let's go through the possibilities. 1. Ethical conflict. If a lawyer believes their client is saying things in court that they cannot verify, or worse, things that contradict prior filings, they have a duty to distance themselves, silently, if necessary. 2. Strategic disagreement. Not all fractures are ethical. Some are tactical. One part of the team wants to play it safe, stick to facts. The other wants to go broader, lean on emotional momentum, public sympathy. We already saw the cracks in Harry's testimony, the drift, the shift from dates and documents to trauma and principle. And behind the scenes, that may have been exactly what split them. 3. Reputation preservation. This one's the most cynical, but also the most likely. If a lawyer senses that the case is slipping, and that the public narrative is turning volatile, they may choose to leave early to avoid being associated with an outcome that could damage their future clients or professional standing. And in a case like this, every minute of courtroom behavior is being watched. Every name attached will be remembered. Let me ask you something. If your client was losing control on the stand, ignoring coaching, drifting into narrative, disregarding judicial tone, what would you do? Would you double down, try to contain the damage, or would you step back, let it fall? That's the question that now hangs over Harry's team. And whatever the internal answer was, it wasn't unanimous. Here's where things start to get even more interesting. Because when court resumed the next day, the remaining lawyers were noticeably different. Not in number, in tone. Gone was the relaxed posture. Gone was the nodding along. Now, they were tense. Minimal eye contact. Faster note-taking. Shorter objections. As if they were trying to catch up to something they no longer controlled. And in Harry, the shift was visible too. His answers were shorter, more clipped, more guarded. And that emotional openness, so raw and dominating the day before, was gone, replaced by something closer to calculation. Not confidence. Caution. This introduces a whole new tension. Because Harry's public position, the one he's carried for years, is one of openness. Break the silence. Speak the truth. Expose the media machine. But in court, that kind of openness isn't strength. It's vulnerability. And once it was clear his legal team was no longer aligned, he had no buffer. He was exposed. Alone. Every sentence now had to be his own. Every claim defendable. And the press, they noticed. Day 1 coverage had been sympathetic, at least partially. But by day 2, headlines began to shift. Harry rebuked by judge. Legal team rift in high-profile case. Credibility questions cloud testimony. And once that narrative starts turning, it's almost impossible to stop. Now, let's ask the question you might be thinking. Does this mean the case is doomed? Not necessarily. The facts haven't changed. If Harry can prove unlawful information gathering, if the paper's defense falters, he could still win. But here's what has changed. The court's faith in the clarity of his testimony. The public's faith in the strength of his strategy. And the press's tone in covering this story. And for a man who spent years trying to shift media narratives in his favor, that's a brutal twist. Especially when his own legal team is no longer united behind him. But there's something even more important to understand here. Because this story, this case, isn't just about what happened in the courtroom. It's about what's happening around it. The optics, the pressure, the stakes outside the trial itself. And while the media focused on what Harry said, the judge, the lawyers, they were watching something else. Watching how he handled pressure, how he responded when things didn't go to plan, when the story stopped working. And those observations, they matter a lot. Because courts don't just rule on evidence. They also rule on credibility. And right now, that credibility is more fragile than ever. But the most surprising part, it wasn't just the legal team under pressure. The defense had their own play, one they'd been holding close, waiting. And when they revealed it, even the courtroom gasped. They had been waiting. From the very beginning of this case, through every headline, every leaked interview, every public appearance, they didn't flinch. While Prince Harry's team spoke of trauma, ethics, boundaries, the defense, Associated Newspapers, publisher of the Daily Mail, did something far more dangerous. They stayed quiet, not out of weakness, but because silence builds anticipation. And when they finally responded, they didn't just defend their case. They flipped the courtroom's entire momentum with one simple tactic. They made it about the facts. Think about that. Harry's testimony, up until now, had walked a complicated line, emotional, reflective, even confrontational. But the defense, they didn't get emotional. They got surgical. And their opening strategy said everything you need to know. They didn't challenge Harry's trauma. They didn't dismiss his pain. They didn't attack his character. They went after the evidence. And by doing that, they did something far more damaging. They made Harry's entire case feel unanchored. Let me explain. During cross-examination, the defense attorney, calm, deliberate, barely raising his voice, began asking Harry about specific dates, not just article headlines. Dates, sources, phone call logs. And each time Harry tried to broaden the discussion, bring in larger context, mention emotional impact, the lawyer gently pulled him back. Your Royal Highness, I'm just asking about this article. Could you please confirm whether this detail was already public at the time? Isn't it true that this information had already been mentioned in a previous interview? Over and over, browning the conversation, forcing precision, and what that does, in the mind of a judge, it introduces doubt, not about the harm Harry may have suffered, but about how provable that harm really is. Here's where it gets even sharper. The defense produced public records, some dating back over a decade, showing that many of the facts Harry cited as illegally obtained had already appeared in other places. Speeches, charity press releases, past authorized interviews, even old press pool notes. Nothing dramatic, nothing illegal, but just enough to suggest this information wasn't private, it was already out there. And for every time Harry said, "I just knew this came from hacking," the defense calmly held up a timeline, cross-referenced it, showed it had appeared in a press release from the palace, or even from Harry himself. The implication? If everything feels like an intrusion, even the public becomes suspicious. Now here's the contradiction. Harry's whole argument hinges on the idea that some information, though technically public, was obtained and used in a way that felt invasive, targeted, cruel. That's a fair argument, and in principle, it holds weight. But in court, feeling isn't enough. You have to show how they got it, and why that method was illegal. Otherwise, it's not surveillance. It's reporting, and that's the razor-thin line this case is now walking. Let me ask you something directly. If a tabloid publishes a private fact, but that fact was mentioned once in a forgotten charity Q&A 2 years prior, is it still a breach? Is it ethical? Sure, or maybe not, but is it illegal? That's what this trial has to prove, and the defense knows it. So instead of fighting Harry's emotions, they're focusing the court on process. Where did we get this? Was it public? Was it newsworthy? And perhaps most dangerously, did you, Your Royal Highness, already tell this to the press at some point? One moment stood out. The defense pulled out an old article from 2014, one of the very same pieces Harry had flagged as a violation. It featured details about a trip he'd taken with a then-girlfriend. In his testimony, Harry insisted that the dates and location could only have been obtained through illegal surveillance. But the defense presented a screenshot of a now-archived palace press release, dated 5 days earlier. Same location, same timeline, and the press release, approved by the communications office that reported directly to Harry at the time. The courtroom was silent. Harry looked caught, not lying, not cornered, just off balance. Because that one slip changes everything. It suggests the story wasn't planted. It wasn't stolen. It was simply read. And in court, that destroys the foundation of an entire claim. This brings us to a broader tactic, and it's one of the oldest in the book. The defense doesn't need to win every argument. They just need to make the case seem too messy to rule in favor of. They need to poke holes, disrupt narrative, cloud timelines. And that's exactly what they're doing. Not aggressively, not emotionally, just with quiet persistence. And it's working, because suddenly, the burden isn't on the Daily Mail to explain why they published what they did. It's on Harry to explain how he knows the information was illegally gathered. And when that burden starts to shift, the case begins to tip. Let me say this clearly. This isn't about denying the trauma. This isn't about saying Harry wasn't targeted. It's about the legal burden of proving that targeting was done through illegal means, not just ruthless reporting. And if Harry can't make that case airtight, the defense wins. Not because they're right, but because the system requires proof, not passion. Now, you might be thinking, what about the other cases? The lawsuits against other tabloids? The phone hacking claims? Good question. Harry's team has built a constellation of cases over the last few years, trying to demonstrate a broader pattern of misconduct. But this trial? This is the most exposed. And if the defense wins here, they don't just win the verdict. They win the narrative. That Harry overreached. That the facts weren't strong enough. That the story couldn't hold up under pressure. And that's the real danger now. Because Harry came to court not just for justice, but for vindication. And that kind of vindication, it doesn't come from emotional testimony. It comes from airtight timelines, forensic data, chain of custody documentation, things his team seems to be losing control of. But the defense wasn't finished. Because just as the court was beginning to regain its rhythm, just as Harry seemed to be back on script, the defense made one final move. They requested the court admit a new document. one not previously disclosed. A private briefing memo, dated years earlier, detailing Harry's own team's cooperation with select journalists, controlled leaks, approved narratives, negotiated access, and in a single motion, they flipped the story again, not from victim to villain, but from isolated target to willing participant in a game he now claims to condemn. And if that document is authenticated, everything changes. There was a beat of silence. The kind that doesn't usually happen in court, unless something's landed hard. That document, quietly introduced by the defense, wasn't dramatic in appearance. Just a few pages, neatly formatted, dated, but its implications, sharp, deliberate, destabilizing. A briefing memo, years old, marked confidential, authored not by a tabloid, but reportedly by a member of Harry's own communications staff, and it outlined something uncomfortable. How to frame a specific personal story about Prince Harry to the press, voluntarily, preemptively. A story Harry now claims was leaked against as well. That's when it all started to unravel, not because of a mistake, but because the story no longer matched the structure. And the courtroom could feel it. Let's slow this down, because this moment is where the trial stopped being just about wrongdoing and started being about credibility. The memo didn't contradict everything Harry had said. It didn't prove he was lying, but it did something worse. It complicated the narrative just enough to weaken the foundation beneath his entire claim. Because now, the judge wasn't just asking, was this information illegally obtained? He was asking, were there moments where the prince cooperated with the very press he says violated him? And that changes everything. Let me ask you something. Can someone be both a victim and a participant? Can you condemn the machine after benefiting from it? The answer isn't simple. And that's why this document is so dangerous. Because it doesn't show hypocrisy, it shows ambiguity. And in court, ambiguity is lethal. It allows the defense to say, look, this isn't black and white. This is someone who has played both sides. And when a judge hears that, doubt settles in. And doubt, not anger, is what loses trials. So what was actually in the document? We still don't know the full contents. But according to on-site reporters and legal summaries, it included the following: a recommended narrative for a specific trip Harry took with a then-partner, talking points for palace-approved correspondence, anticipated questions and vetted answers, a media timing strategy, suggesting when to let the story appear in select publications for minimal backlash. Minimal backlash. That's a chilling phrase in the context of a privacy lawsuit, because it implies calculation, not intrusion. Now, here's where the contradiction tightens its grip. Earlier in his testimony, Harry had described that exact same story, down to the timing and personal details, as something that left him violated, ambushed, and trapped. He said it was clear someone had been surveilling him. He said no one could have known those details. Except now, we see that someone did know, because someone on his team may have authorized it. And that's not just a bad look, it's a fracture. In the timeline, in the logic, in the trust. You could feel the shift. Harry's demeanor changed. He looked down longer between answers. His voice, still steady, was slower, more cautious. This wasn't just about defending against intrusion anymore. Now, he had to explain inconsistencies, why this document existed, whether he'd seen it, who approved it. He denied authoring it, denied remembering the language, admitted the communication office had sometimes prepared external guidance. But that's not a denial. That's a distance. And distance doesn't always protect you in court. Sometimes it isolates you. Let's step back for a moment, because what we're witnessing here is the collision of two very different versions of truth. Narrative truth, the story Harry has been telling publicly for years, and evidentiary truth, what the paper trail actually shows. And those two truths, they don't always align, because narrative truth is emotional. It's built on experience, memory, trauma. It's felt more than it's documented. But evidentiary truth, that's brutal, cold, technical, dates, timestamps, source attribution. So when Harry says, this felt like a violation, but the records say, your office briefed that story, the contradiction doesn't just weaken the claim. It creates a credibility paradox. Because now, the court doesn't just have to weigh what happened. It has to weigh whether Harry believes his own version of events, or whether he's reshaping it under pressure. Let me be clear, that doesn't mean he's lying. It means memory, trauma, and public life are messy. Stories evolve. Context blurs. What felt like betrayal might have once been consent wrapped in PR spin. But courtrooms aren't built to process nuance like that. They're built to test consistency. And this was a break in consistency. The defense capitalized quickly. No theatrics. Just calm questions. Would you agree this document reflects an internal strategy? Was your office in the habit of briefing the press in advance? Do you remember approving this particular message? Each answer was hedged. Each hedged answer added friction. The judge? He didn't interrupt, didn't issue another warning, but he wrote everything down. And that silence, that lack of commentary, that's the most telling part, because it meant the court was processing. And once the court starts processing contradictions, you're no longer on offense. You're scrambling. What does this mean going forward? Well, it changes the stakes. Because now, Harry isn't just testifying as a victim of media abuse. He's testifying as someone whose own team may have played the same game. And that doesn't kill the case, but it introduces a shadow that will follow it to the very end. A shadow that says, maybe this isn't just a case about right and wrong. Maybe it's about who controlled the story and when. And that idea, that maybe Harry's team once played the very same media manipulation game he now condemns. That's the part the press is going to eat alive. And if jurists start seeing it the same way, this trial might already be lost. But it's not over yet, because in the next round of questioning, Harry said something no one expected. A single phrase that shifted the temperature of the room, that made even the defense attorney look up. And when the judge asked him to repeat it, the courtroom stopped breathing. I never fully trusted them. That was the phrase. 6 words. Quietly spoken. No emphasis. No raised voice. But they landed like a dropped glass in a silent room. Because the them Prince Harry was referring to was his own former communications staff. The very people who had authored, or at least approved, the strategy memo the defense had just introduced. The moment hung in the air. And for a second, even the defense attorney didn't move. As if recalculating what door had just been opened. It wasn't just a defensive comment. It was a fracture in the palace wall, made public, under oath, in open court. And it wasn't supposed to happen. Here's why that matters. Up until that point, Harry had carefully walked a line between self and institution, even while criticizing the press, even while discussing how the firm handled Meghan or ignored his pleas for protection. He'd stopped short of turning on the machinery itself. The advisors, the aides, the strategists behind the scenes. But that one sentence, it broke the spell. It introduced the idea, to the court, that not only was Harry the victim of media abuse, he may have been misled, or worse, sacrificed, by his own team in the process. And if that's true, the entire dynamic of the trial changes, because it becomes a triangle, not just Prince versus press, but Prince versus palace versus press. And in that setup, no one wins cleanly. Let's unpack what actually happened in the courtroom. The defense had just presented the memo, the one suggesting Harry's press team had coordinated certain media narratives in advance. The goal was to suggest contradiction, that Harry wasn't just a victim of media intrusion, but an active participant in managing coverage when it suited him. That alone would have been damaging. But Harry's response, he didn't deny the document. He didn't attack the press office directly. He simply said, I never fully trusted them. A statement loaded with ambiguity, frustration, maybe even quiet rage. But also, a tactical misstep. Because by questioning his own team's loyalty without offering clarity, he introduced doubt without providing evidence. And that's the kind of statement that can backfire in court. Let me ask you something. Have you ever watched someone speak the truth, but in the wrong room? That's what this felt like. Because in another setting, an interview, a memoir, a docuseries, those words would resonate. They'd play as honesty, as courage. But in court, they sound like distance from responsibility. And when a witness starts pointing to others, especially their own advisors, especially after being caught in contradiction, it risks looking like deflection. And the judges aren't swayed by optics. They listen for structure, accountability, coherence. And suddenly, Harry's testimony had introduced none of those things. Just shadows. This is where the larger contradiction reveals itself. Because Harry, more than any royal in recent memory, has lived in 2 parallel realities. The public image he controls, through interviews, books, Netflix deals, and personal narrative. the legal system, where none of that matters unless it holds up under pressure. And when those two worlds clash, something has to give. This trial is forcing a collision between what Harry feels is true and what the court can prove is true. And that's a brutal place to be, because even if the emotional truth is undeniable, the years of trauma, the invasions of privacy, the toll on his marriage and mental health, that doesn't mean it holds up in court, especially not when the public version of events begins to diverge from the documented one. Here's another piece of the puzzle: media coverage. Because while the courtroom operates on documents and precedent, the world outside it runs on headlines and clips. And right now, the headlines are turning. Once sympathetic coverage is now skeptical, not because Harry is unsympathetic, but because contradiction makes for better drama, and that drama isn't kind. You start seeing phrases like, Harry contradicts own team, Palace PR under scrutiny, legal case marred by inconsistencies, and each of those headlines plants a seed, a suggestion that maybe, just maybe, this trial isn't about proving the press was wrong. Maybe it's about Harry trying to correct a narrative that's long since slipped out of his hands. Now let's go deeper, because behind all this, the testimony, the optics, the emotional weight, is something more delicate: trust. Who does the public trust in this story? Who does the court trust? And more importantly, who does Harry trust? Because once you say you don't trust your team, once you imply they may have fed stories to the press without your full knowledge, you raise a terrible question. If you didn't control your own narrative then, do you truly understand it now? And if the court begins to believe that even Harry can't fully trace where his story begins and ends, that's not victimhood, that's uncertainty. And legal cases cannot be built on uncertainty. Let's pull back. We're now at a point where everything is overlapping. The public doesn't know which Harry to believe, the wounded prince or the one now casting doubt on his own staff. The court doesn't know which story to trust, the one told from memory or the one documented in briefings and communications. And Harry himself, he's caught in the middle, emotionally present, legally exposed. This chapter of the trial, this turn from press attack to internal contradiction, has made one thing brutally clear. The hardest part of fighting a media war in court isn't the cross-examination. It's the moment you realize your past strategies, your compromises, your half-truths, your selective silence, are now admissible, and you no longer control how they're interpreted, not by the public, not by your team, not even by the judge, but just when it seemed like the momentum had turned for good, the prosecution pulled something unexpected: a last-minute witness, a former royal aide, subpoenaed, silent until now, and what she revealed, off record, behind closed doors, sworn under oath, might just blow the defense's case wide open. It wasn't on the schedule, no media advisory, no court bulletin, not even a leak, but somewhere behind the scenes, while the press was still dissecting Harry's remark about not trusting his own team, a name was added to the witness list. A quiet addition, last minute, strategic, a former palace aide, not a front-facing staffer, not a spokesperson, someone behind the scenes, the kind of person you don't notice until their absence becomes suspicious. And when that person was sworn in, the atmosphere in Court 76 shifted again. No one expected what she would say, especially not the defense. Because for the first time in this trial, the silence inside the palace began to crack open. Here's what we know. The aide, whose name is still being partially withheld from press reports for security reasons, worked in the communications office during the very time period under dispute, roughly 5 years, trusted, looped into all internal strategy meetings. And most critically, she wasn't part of Harry's current team. She was from the old palace structure, before the split, before the Sussexes left. In other words, she wasn't testifying for him. She wasn't loyal to his side or the defense. She was there because the court compelled her. And that neutrality made her testimony devastatingly powerful. Her demeanor was clinical, not dramatic, not defensive. She answered questions with short, precise statements, rarely elaborated, never speculated. But the content told a story the court hadn't heard yet, one that complicated everything. Again, let's pause for a second. Up until this moment, the defense had a clear advantage. They'd established inconsistencies in Harry's claims. They'd introduced documentation suggesting his team had occasionally authorized press leaks. They'd framed Harry's testimony as emotional, imprecise, reactive, and it was working. But this aid, this unexpected witness, brought in one crucial missing piece. Context. Here's what she revealed. Yes, briefing memos existed. Yes, press strategies were coordinated internally. Yes, certain stories were managed to control narrative fallout. But, and this is where the courtroom leaned in, not all of it was done with Harry's knowledge. In fact, she said, it was not unusual for senior staff to brief select reporters without the principal's direct consent, especially when under pressure from other royal households. Let that sink in. She wasn't just confirming internal press manipulation. She was implying that Harry, despite being the subject of the story, might not have known how much of his personal life was being filtered out through back channels, and worse, that some of it may have been done to protect other royals at his expense. Now think about what that means in a courtroom. Suddenly, Harry's seeming contradiction, denying knowledge of briefing memos related to his own movements, isn't necessarily a contradiction. It might be true. He might have been left out of the loop. Not always, not everywhere, but enough to raise doubt, enough to put the burden of proof back on the publisher. And that's what made the defense shift, visibly, for the first time. The lead attorney frowned, whispered to co-counsel. They didn't object. They didn't challenge, because they weren't sure what she would say next. This wasn't part of their script. Let me be clear. This didn't flip the case. It didn't prove hacking. It didn't erase the contradictions in Harry's earlier testimony, but it changed the temperature. It introduced a chilling possibility that the very institution Harry had once represented, the one he believed would shield him, may have exposed him to the same press violations he now claims were illegal. And if that's even partially true, it reframes the whole trial, not as a clean fight between right and wrong, but as a proxy war between a man trying to reclaim control of his story and a machine built to keep that control out of reach. There was one more moment, brief but unforgettable. The prosecution asked the aide, "Were you ever instructed to omit Prince Harry from key editorial decisions involving press coordination?" Her answer? A long pause. Then, "I was instructed to prioritize other senior members' reputations. If that meant withholding briefings from the Sussex office, it was understood. Understood. Not debated. Not resisted. Understood." And that single word, it said everything. It told the court and the country that Harry wasn't always in control of his own story. He wasn't even always consulted. And that turns this case, at least partly, into something else. Not just a legal battle about phone records, but a story about erasure. And who gets to speak for whom? Now, the defense tried to recover. They shifted questioning quickly, brought the witness back to neutral ground. They emphasized that even without full knowledge, public details still appeared in the press legally. But the damage was done, because the court now had a new idea in its head, that even if the press didn't always break the law, they might have been enabled by a system that quietly chose silence over loyalty. And silence, voluntary or not, can carry weight in court. Let's not overstate it. This doesn't make Harry's case bulletproof, but it rehumanizes it. Suddenly, those moments in his testimony that felt unsure, hesitant, they make sense, not because he's evasive, but because he genuinely might not know what was done behind his back. And if that's true, the court has to consider, what is fair in a system where even the subject of the story doesn't know who's telling it? That's where control finally slipped. Not from the press, not from Harry, but from the structure around him. And the people in that courtroom, they felt it. For the first time, the question wasn't just, did the press go too far? It was, who let them? And the answer might lie deeper than anyone imagined. But as the court began to adjourn for the day, reporters noticed something else. A new face, seated quietly near the back. Not press, not public. Legal observers confirmed it hours later. Another